The broadcast is now starting. All attendees are in listen-only mode.
Good evening, everybody. Welcome to Victoria Home Chat. My name is Bruce McCallum, and I'm a realtor with DFH. And I just wanted to welcome everybody tonight to the webinar. And if you wouldn't mind, type in your name and where you're from, and it'll show up on my screen here. And that would be great to know where everybody's from tonight. I'll just give you a minute to do that. Okay, that's great. And everybody can hear me. If you can see me mouthing, moving my lips, but you can't hear me, type in the little chat box down below. But like I said, my name is Bruce McCallum. I'm with DFH Real Estate, and welcome tonight to the second webinar of Victoria Home Chat. And what's this all about? Well, I started this last week after a couple months of thinking about starting a webinar, and I wanted to do that to provide home buyers and sellers a place to go and to learn about the transaction process and to learn about other issues related to buying and selling real estate. I'm a firm believer that knowledge is power, and with this knowledge it'll help you during that transaction period, or it will help you in other areas with real estate. The key to Victoria Home Chat, just like its name sounds, is this is an informal program where we encourage interaction. We're going to have a live Q&A. But during the program, if you have a hot question that you want to ask, by all means, type it in that little box, that chat box. We're going to have weekly series every Thursdays at 8 p.m. If we run up against a special, for example, the Canucks are playing playoff hockey soon. If we run up against a special schedule, we'll change that and we'll let everybody know. Also, one other thing that's going to be nice, if you happen to have to run out during the webinar, all these webinars will be recorded and we'll have an archive of them. So tonight, we're going to be talking about some of the basics, real estate transactions, some of the legal basics, and we'll also touch just a little bit upon estate planning. I think that for the buyers, the uninitiated, and some of the ones that haven't had transactions for quite a while, I think that a little brief primer on this or updated information is really handy. So I met Christian Hoy, who's a lawyer in town. Met him a couple weeks ago, maybe a month ago, and we struck a good relationship and started chatting about some ideas. And I thought that he had some really good ideas that we could share with tonight. And I'm really happy to have him here. So I'm going to get him into the webinar in just a second. A little housekeeping. If you're not quite sure where to type in your question, if you look to the right on your screen, you should see this question box. So just click on the empty box and type in your question, and that should come to me. So let's bring Christian in here. We're going to unmute his microphone and we'll turn on his camera, and we'll wait just a second till he comes in here. Hey, there he goes.
Good evening, everyone.
Christian, how are you?
Very good, thank you, Bruce. How are you?
Hey, I really appreciate you being here tonight. I value your time, and so tonight we're going to talk about some of the basics. Just a little bit more about you, Christian. You were called to the bar in 2010. You told me. You went to UVic Law School. You specialize in real estate law and contracts. But you also do quite a bit in wills and estates and especially corporate law, right?
That's correct, yeah.
Yeah, that's great. Okay, so let's jump into this. Christian, I'm just going to be here to maybe jump in with some other questions if I see them pop up on the screen. But why don't you kick this off for us?
Wonderful. First off, I'd like to thank you, Bruce, for inviting me to participate in this new and innovative session to allow people to learn more about real estate in Victoria. As Bruce said, I'm a lawyer with McConn & Dion O'Connor & Pearson, which is a full-service firm in Victoria, and I specialize in real estate. Bruce has asked me to talk about the basics of real estate transactions from a legal perspective, and also provide a brief primer for estate planning, and this will certainly be very brief. I'm often asked at what stage a lawyer should be retained. I always recommend to contact a lawyer once the contract or purchase and sale is entered into and before it becomes binding, that is, before the conditions lift. If you retain a lawyer after the conditions lift, there's a couple problems that can occur. The primary one is the fact that it's now a binding contract. So therefore, if the lawyer reviews the contract and has concerns, it's hard to make changes. Furthermore, if the lawyer reviews title and there's issues with respect to title, it is, again, difficult to make changes because you're now in a binding contract. So what you'll want to do, ideally, is retain your lawyer prior to lifting those conditions. And therefore, the lawyer can advise you with respect to title. Now, title is the document that's found in the Land and Title Office. It shows who owns the property and any legal encumbrances against the property. This would be the common things, such as your mortgage. But also it can have restrictions, such as rental restrictions, suites, whether or not you can have suites, where you can build, whether or not you can remove trees from the property. If there's any liens on the property, things like that. So certainly things that you want to be aware of and want your lawyer to review for you prior to lifting those conditions. Furthermore, if you're purchasing a new strata, so for example a condo, the lawyer can also review the strata disclosure document. And the lawyer can advise on things that you may wish to know about, so things like fees that you may incur. Whether or not floors of the entire strata units are all sharing utilities. This may be a big issue for you if someone's using more heat than you, or restrictions on things such as utilities, or pets, or rentals. So it's very important to have your lawyer come in earlier than later, ideally before you lift those conditions. The next thing that Bruce wants me to talk about today was the contracted purchase and sale. Now this is the central document in any real estate deal, typically prepared by the buyer with the assistance of the real estate agent, and typically contains a number of conditions. There's a number of provisions in the real estate contract, and most of these are fairly common sense. Who are the parties to the contract? What is the property being purchased? What is the purchase price? How much is the deposit? When is the completion date? Things such as this. But this is not an exhaustive list, of course. The contract will also contain a number of conditions. Conditions are things that must occur prior to the contract becoming binding. These are also known as subject to. You have your contract, you make your offer is accepted, and it's subject to. So there's a number of things the buyer has to do or can choose to do prior to lifting those conditions and making it the binding contract. So some of these things they'll have on there is financing. The buyer will want to ensure that they have adequate financing in place so they purchase the property before they lift that condition. Also property inspection, very common. The buyer will want to have a qualified inspector come to the property and view the property. They'll advise whether or not they have concerns, and if the buyer is willing to accept these concerns, then they'll want to move forward with the purchase. Also, title insurance is a common one, and this is again where the lawyer reviews title to advise you on whether or not there's any concerns with respect to that. Once the buyer lifts these conditions, you have a binding contract.
I'm just going to jump in here. I got a question here, Christian, and a concern too. In Victoria, many of the homes were built well before 1950, and a lot of times the oil tanks were an issue. Well, let me put it this way: they were buried in the ground.
Of course, yeah.
And it's very common for us to put that as a condition, a subject condition. In other words, wording such as subject to the inspection and removal or remediation of that buried oil tank. Have you run in? I'm sure you're running into that, but have you run into any special considerations regarding that?
Yeah, I've run into that actually professionally and personally, where there has been a buried oil tank on a property I was making an offer on, and I asked the vendor to render it inert, and they actually refused to. So they said that's not something we're willing to do at this stage. So the contract fell apart, and they actually ended up continuing to list it, and they sold it to someone else. So that person decided to take the risk of having that tank there. And it may not be a risk. It may be that the tank is fine. It may be that there's no oil in that tank. Maybe that there is oil in the tank and it's never leaked. But for me, I had a concern of the implications of the fact that that tank could have oil in it, the oil could have leaked. I purchased the property, and I'm the person that's responsible for the environmental remediation, which can be a huge expense. So it's certainly something you want to do in scoping that yard and making sure that it's not there, and if it is there, it's rendered inert, and you're advised, usually it's the fire department, I believe, that advise you that it is done properly.
So let's say that a buyer goes ahead with this. The seller says, no, I'm not going to pay for that. You, Mr. Buyer, have to accept that responsibility. Does the buyer automatically have a responsibility to get that done? Who checks on that? Who will know about that?
As far as I know, I don't think anybody checks on it. The concern is more that it's sitting there. It's a ticking time bomb, basically. And so one day it starts to leak, it leaks into the stream or it leaks into a neighbor's yard. Then at that point, people do start checking. The environmental, some environmental committees, I'm not sure who it is, to be honest, does do some just check. They'll find out if it's coming from your yard. At that point, you will be responsible for rendering it inert and cleaning everything up. And we've seen a number of tanks that have been filling inventory recently.
Well, you know,
it does tie back to the owner.
Yeah, and this is something that our audience should know. This is the value of having a professional team with you. And when I say team, I mean a team of a realtor, for example, me, a lawyer, Christian, and perhaps other experts to help you through these issues, because the typical buyer is totally ignorant of some of these things. And
I'm glad you sorry.
No, I think that they're ignorant of these things, and it just goes to show you the importance of having a team around you to protect you.
I agree, and I'm glad you bring that up. I don't see that condition in most contracts. So a lot of realtors are using it, and some realtors aren't. So it's good to see that realtors are using it, good to see that you're aware of it. So I think that's a great service for your clients to make sure the clients are aware of that and check into that. And I believe that the inspection is typically done for free, actually.
Yeah, good, good. Okay, well, great. I'll let you continue here. Okay, thank you.
All right, you're very welcome. The next thing I want to talk about is the lawyer's role in the transaction. So there's going to be two lawyers typically, one acting for the buyer and one acting for the seller. The lawyers will help the parties get what they bargained for. So for the purchaser, it's ensuring that they're getting clear title. For the vendor, the seller, it's ensuring that they're getting the finances, the funds, the sale price. First off, the documents will be sent to the lawyer by the lender and by the realtor. Now, when you do register title, so when title is transferred to you, if there's more than one person going on title, the lawyer will typically ask you how you want it registered. Do you want it registered in joint tenancy or tenancy in common? Joint tenancy is very common with spouses. And this is when, if one person passes, or one person passes away, the property automatically transfers to the other party. There's no probate tax involved, and both parties are equal owners of the property. Tenants in common, on the other hand, is where each party owns a share, and this share is actually set out on the title. It'll show that one party owns 60% and one party owns 40%, or something like that. Now the difference here is that when one party passes away, the property goes through their estate and to the beneficiaries. It doesn't automatically go to the other party. The reason this is really important is that it can have potential tax implications. So with joint tenancy, it goes directly to the other person, which means it does not go through the estate. Since it doesn't go through the estate, there's no probate taxes. Probate taxes are about 1.4% of the gross value. And in Victoria, our home price is 1.4% can be a fair amount. For common, that share that that person owned when they passed away will go through their estate, and probate tax will have to be paid on that share. So very important, joint tenancy versus tenancy in common. So the lawyer will also prepare the transfer documents, and if there is financing, the mortgage documents. So the lawyer will then meet with the client to sign the documents and effect the property transfer. So what do you really need to know as the buyer or the seller? Basically, when you're the buyer, you'll want to advise your lender, if you have financing, and your realtor of what lawyer you'll be using. Those parties will then provide the documents to your lawyer, who will then contact you. The lawyer will contact you typically a couple of weeks before closing to set up a meeting with you. And that meeting is typically very close to closing, 2, if not 3 days prior to completion. They'll come in, they'll sign a stack of documents with the lawyer. It'll be about a half-hour to 1-hour meeting, and after that, the lawyer will do everything that needs to be done to effect the property transfer.
I'm just gonna jump in here again. I had another question here. When you say provide sale proceeds, can that be a wire transfer? Is it a check that you actually have to take a deposit? Or can it be a choice? Is it up to the buyer or to the seller? Excuse me.
Yeah. So what I typically do is I meet with the client and I go through all the costs that are involved, and so exactly how much at the end of the day is going to be taken. There's going to be, I'll get into it later on, but there's going to be your sale price, less the expense that you have, so realty fees, if you've got mortgage penalties, things like that. So I'll tell you exactly how much is coming to you. And there's usually 3 methods that we can provide the money to you. The first is a direct deposit. And so if you want to do that, I just ask for your bank information. So avoid check and such for that. So direct deposit on the day of the sale. Second would be a check sitting at our office waiting for you to come pick up, which will be ready on the day of the sale, and that's a bank draft. And then finally would be a check delivered to you, so mailed or couriered to your address. So 3 options there.
And when it comes to the fees that you paid for realtors on either the buyer side or the seller side, how is that done? Are you sending a check directly to the real estate brokerage?
Yeah. So usually there's a deposit that's being paid already. So if someone makes an offer to purchase property. Purchase price is $500,000. They put down a deposit of $25,000. That deposit is typically held by the realtor. So what happens is the realtor typically takes their fee out of that $25,000 and forwards the remainder of the fee to us. So that's for one of the realtors. Of course, there's going to be 2 realtors, typically, one for the buyer and one for the seller. We will send the proceeds to the other realtor.
Mm-hmm. Good. Okay, great. Great. Let's move on here. Okay.
So not the client that's going to...
No, go ahead.
There's certainly not a client that's going to be cutting a check. Everything will be taken care of by the lawyer typically.
Yeah, it's a very common question that I get. They want to know, the money process, not only how much it is, but, do I need to do this or how can I transfer and all this kind of stuff. So that clarifies it. That's great. Okay, here we go. Some of the costs, and this is obviously a question on everybody's mind.
And just to clarify that a bit further as well, what we do in our firm at least is if you're purchasing, we will send you a statement, usually by email, about a week or 2 prior to the actual meeting that you're going to come and meet with me. On that, it'll explain exactly the fees that are involved for everything, not just for my fees, but also for property taxes, for realtors, things like that. Excuse me. And so it'll show exactly how much has to be brought in. A check will be brought in for that. And after you bring that check in, there should be no further fees that are going to be incurred for the actual purchase of the property. That'll cover your title insurance. It'll cover your legal fees. It'll cover your purchase price, all of that kind of stuff. So you'll have that set up for you in advance. Now, with respect to the cost to consider, there's 2 sets of costs depending if you're purchasing or depending if you're selling. So if you're purchasing, there's obviously the purchase price. In addition to that, there's property transfer tax, also known as PTT. This is a provincial tax, and it's applicable on all purchases of real estate in BC. It's 1% on the first $200,000 of the purchase price and 2% thereafter. Now, I said PTT is applicable on all purchases. However, there are some exemptions. Now, the most common one is the first-time home buyer. And if you're a first-time home buyer, you're buying in BC, and the purchase price is less than $425,000, there's a full exemption, meaning no PTC payable. If it's between $425 and $450, there's a partial exemption, and if it's over $450, you have to pay the full PTC, and you've earned up your first-time home buyer's exemption. And being it's 1% on the first 200K and 2% thereafter, it can be fairly steep. You'll want to think about this number when you're making your offer. In addition, you're going to pay legal fees. If you're making a purchase and there's financing involved, I would typically bank on the fact it's going to be about $800 at least, plus GST and non-purchase price. There also may be CMHC. CMHC is mortgage loan insurance. Now, the bank may require this depending on the loan that they're providing you with. Typically, if you're putting a deposit down of less than 20%, you'll be required to pay CMHC. And again, this can get quite expensive. So you'll want to talk to your lender prior to finalizing everything. If you do not have a state of title certificate, or sorry, if you don't have a survey certificate, your lender will often require you to get title insurance as well. This is a one-time fee. It's usually about $200. Additionally, as the purchaser, if you are buying the property after July and the vendor has already paid the property taxes, you're going to have to reimburse them for a portion of the property taxes. And this is because when you buy the property in, let's say, October, for example, they've already paid the tax for the entire year. They paid them in July. Therefore, they paid them for October, November, and December. Yet you're going to have the property during that period. You'll have to reimburse them the amount of time for that period. Now, your lender should be able to go through most of these costs with you, so you should be aware of all these costs. If you have further questions, you can certainly contact your lawyer to discuss this. As far as legal costs, most lawyers will have a set fee for doing the actual transaction. So when you phone about these questions, reviewing title, or questions about costs, things like that, your lawyer is not typically going to be charging extra for this. It's usually all built into that one fee. So I wouldn't hesitate to call about that. You can certainly ask your lawyer if they're going to be charging for that. It's certainly something I don't. I figure it's all part of that one fee. Now, if you're selling your property, there's a different set of fees that you may incur, which you usually will incur. You'll have the realtor fee. So the vendor typically pays the realtor fee for both the purchaser and the vendor. They pay both sides of the realtor fee. In Victoria, it's typically 6 and 3%. So 6 on the first 100K, 3% thereafter. If you have financing, if you have a mortgage on the property, it's a closed mortgage. This means that you can't make excessive payments on your mortgage. There's going to be restrictions on how much you can pay out. If you want to pay out the entire mortgage, you may pay a penalty. Again, you should discuss this with your lender to determine how much it's going to be. And if you're selling prior to July, you will have to reimburse the purchaser for property taxes, as they'll pay the property taxes in July, and you've had the benefit of the property. And for the sale, there's also going to be legal fees. These are usually about $750 plus taxes. Now, that covers pretty much everything I want to talk about as a brief intro to the legal implications of the real estate purchase and sale. If you have any further questions, please do not hesitate to ask through Bruce on the chat line there, or certainly do contact me at my number below. Bruce also asked me to give a brief introduction into estate planning. So there's 3 things I'll talk about quite quickly, and that's first off your will, next your power of attorney, and finally the representation agreement. Now keep in mind this is going to be quite a brief overview, so please don't hesitate to ask any questions if you have them. So with respect to a will, I would advise if you have property or if you have children, you should have a will. Without a will, you'll have no control of who will manage your estate, who will be the guardian of your children, and how your estate is distributed among your relatives. Now, the classic example I always give is my wife and I own a house. If we were in a car accident and we had no will and we had no children, and we both passed away in that car accident, essentially at the same time, the legislation says that since my wife is younger than me, everything that I own and everything that she owns and everything that we own will transfer to her because she's the younger party. Since she also passed away in that accident, everything's going to then go to her family through the legislation. So everything that we own together, everything that I own, will go to her family. Now alternatively, in that same accident, I survive her for 10 minutes. half an hour, whatever it may be, but I also pass away eventually. In that circumstance, everything comes to me and then goes to my family. So we've got two results here. One, everything goes to her family. Two, everything goes to my family. Clearly, this isn't what we want. We want to ensure that it's going to be split between our families, or if one family pays some debt or provides funding or whatever it may be, we want to ensure that the money goes where we want it to go. So we want to have a will in place.
I just want to jump in here.
Think about with respect
Can I jump in here just a second? You know, this touches upon the ownership, and when we fill out a contract of purchase and sale as well, correct? Who the house goes to.
Yeah.
And this
that's what I mentioned before, is the joint tenancy versus tenants in common.
Yeah.
So if you register the property as joint tenants and one of you passed away, it doesn't matter what your will says. That property will automatically go to the other party.
Okay.
And you see this between spouses. So the classic example is husband and wife have it in joint tenancy, therefore the survivor obtains it at the end of the day. But this can also be used for tax planning purposes. And so we also see elderly parents. They have a property, it's worth a fair amount of money, and they're concerned about the fact that their family can pay probate taxes. So what we often see is those parents will put children or a child on title as a joint tenant. Therefore, when parents pass away, property automatically goes to children or child with no probate tax payable. And in most cases, that would be the beneficiary under their will anyway. So it goes to the same person, but avoids those taxes. Now, there are risks of doing that as well. You're putting someone up on title of your property. If that person has a creditor, gets into an accident, gets divorced, something like that, this is another asset that that child owns that that creditor can go after. We can avoid this concern by making a bare trust, but it is something that you want to get legal advice with respect to this sort of estate planning.
You know, what I'm thinking here is that gets back to some of the earlier slides. You know, when does the lawyer come in to play the part that he or she does? And I think the earlier the better, because like I said before, knowledge is power. And whether you're a seller or a buyer, if you know some of these issues, you're just going to protect yourself much better.
Definitely, and unfortunately I don't see that. I really try and encourage people to come in earlier, because there's no, I don't want to speak for other lawyers, but for me there's no extra cost. I have that set fee for doing a real estate deal. So have the lawyer come in earlier, get them to review the title, get them to review the contract, make sure there's no concerns. And like I said, it's very uncommon that I do see concerns, but as a good insurance policy, I might as well get them to come in and look it over for you.
Right, exactly. Good. Okay, thank you. That's great. Okay, well then I'll move on to this next slide here. Power of attorney. I think a lot of people have heard the term, but I don't think many really know what it means.
Yeah, so we have the will, which we talked about. That's looking after life. Power of attorney and representation agreement, the document I'm going to talk about next, are both during your lifetime. They're commonly referred to as incapacity planning tools, but they're not just for incapacity. So power of attorney permits an adult to grant authority to another person to act with respect to legal or financial matters on behalf of the adult. So what that means is the adult, the person making the power of attorney, can appoint an attorney, the person acting for them, to make financial decisions. So they can assist you with your banking, paying your bills, your mortgage. Basically, anything to do with finances that you can do, they can do. So it's a very popular, very powerful estate planning tool. A lot of people use it for incapacity planning, because when people get to that stage where they no longer have capacity, they'll want someone else to make these decisions for them and put them into effect. But also it can be used in the current as well. So if you're overseas, if you're traveling, if you can't do what you need to do, someone can do it for you. So they are quite common. Now, so those are the advantages that having someone else assist you. The other advantage is you can avoid common-ship application. So if someone loses capacity and there's bills to pay, property to sell, mortgages, things like that, and they don't have a power of attorney, that person that's lost capacity, that has control over these accounts and these assets, can't do what they need to do. And there's no power of attorney, so no one's appointed to do it. So a third party would have to make a common-ship application. This is an application to the court to say that party X, let's use mom and dad have lost capacity, and child needs to assist them with what they need to do. It's good to avoid the commutative application to have power of attorney done in advance, and the reason this is the commutative application takes time, because it's a court application, requires 2 doctors to give you a report and affidavit, so it's going to cost a fair bit of money to get one done. And also, the adult or the parent has no control over who's going to be appointed. With the power of attorney, they simply appoint their child or friend or whoever, whereas the commutative application, the application is brought by the person that is seeking to be the commitee. So the person that's in capacity doesn't have control over who's bringing this application. Typically it's done by a child or a sibling, but you don't have control. The disadvantage of a power of attorney is, as I said, very powerful appointing someone to make financial decisions and take financial actions on your behalf. So there is the potential for abuse. The person you're appointing can go and drain your bank account, they can mortgage your property, they can sell your property, they can do anything you can do. The way to mitigate this is A, appoint someone you trust. So usually it's a family member we see on this, and quite often there's an alternative as well. So appoint husband and then child, or wife then child. The other way of avoiding the abuse is I draft up a letter. This letter is from you to me. This letter basically states that, Christian, I want you to hold my power of attorney for me, and I do not want you to release it to my attorney or to anybody else for that matter. You're only to release it if I give you direct instructions to do so, or if you're contacted by a doctor who says I've lost capacity and needs to release. This will mitigate the chance of something happening or something going wrong, because that power of attorney document will be simply stored in our vault and not released until such time.
I'm just going to jump in here. I'm thinking that this is all really great advice. Can you share with us any real-life examples that perhaps you've seen in your career, talking about maybe something that did go wrong, so people that did not have power of attorney and they ran into some difficulties?
Certainly, yeah. So what I typically see is when you have, and I always use parents and child. So child phones me up and says, Mom and Dad have lost capacity, their bills aren't getting paid, or they've got a friend that's taking advantage of them, or the property needs to be sold, and child is quite concerned about these things, and they can't do anything with respect to it because they don't have any power.
Mm-hmm.
So at that point, they have to bring that commutative application. Yeah, an application can cost $3,000 and upwards from there. It can take a fair bit of time. And the other difficulty is you may have children that are at odds. So one child wants a commutation, and another child has a completely different view as to what mom and dad would want, and is also seeking it. So you can have infighting between the children, which will ramp up the cost, but not only ramp up the cost, but also cause a lot of discord between the family members. Whereas mom and dad have done the power of attorney, appointed someone, that decision is final and binding. So it can avoid that cost, and it avoids the fractioning of the relationship.
Okay. Okay. Now, related to that too, we've got a question about probate. When dealing with a property and the owner dies, and then it has to go through probate. Can you explain that process a little bit? And also, as a second follow-up question, what does that add to the time that the buyer has to deal with before completing on a purchase?
Okay. So when someone passes away and they are the owner of a property, probate has to receive before the property is sold. And same with bank accounts. So if they are the name on a bank account, before those funds can be transferred to the beneficiary, probate has to receive. What probate is basically taking the will. There's a lot of technical stuff behind it, but taking the will to the court and the court saying, yes, this is a valid will. The assets should be distributed in accordance with the will, and the person appointed as executor is entitled to do that. Now, once the person has received probate, the executor, then that person can start distributing the assets in accordance with the will. In Victoria, application for probate, so once you get everything prepared and once it's in front of the court, the registrar, but the court, it takes about 6 to 8 weeks, and that's if everything goes smoothly. So it can slow things down. There is a lot of preparation work before the actual application is done, so we can be looking at 2 months plus before probate is received. I find a lot of people do list properties for sale while the application is being made, and too often see MLS listings which say the property is subject to probate or the sale is subject to probate, which basically means that probate must be received, so the court must approve that will prior to the property being sold. And like I said, it can take 6 to 8 weeks, but it can also take a lot longer if there's concerns in it or if the registrar has any changes they want to see. So it can take a while and can tie things up for a while. Does that answer your question, Bruce? Are you still there, Bruce?
Oh, I'm sorry. Yes, I muted my microphone. Sorry about that. But yeah, thank you very much. That answers the question.
Wonderful. So the next slide is with respect to representation agreement. So as I mentioned, you have a will, which is post-life, and you have representation and power of attorney, which are documents that are used during the lifetime. Representation agreement is truly an incapacity planning tool, and this is because it only comes into effect if the adult loses capacity. If the adult loses capacity, it empowers someone else to make health care and personal care decisions on behalf of that individual. These would include things such as where the individual is to reside, consent to major and minor health care, admission into a care facility, and directions regarding life support, and that's also known as the heroic measures clause. If you don't have one, again, and people need to make decisions on your behalf, again, the commutative application will have to be done. So delay, friction, things like that. In order to create your representation agreement, to create your power of attorney, and to create your will, you must have capacity. It's something that has to be done at the appropriate time. And that really covers everything that I want to talk about in my brief introduction to the will, power of attorney, representation agreement, unless there's any other questions.
Okay. Okay. Yeah, I think the audience needs to remind themselves that the purpose of this webinar is to give you the basics, and I think that it's really important to establish a good relationship with a lawyer, with your real estate agent, so if you have any particular questions, you can go into further depth. But at least this webinar will give you some of the basics that you can work with. Alrighty. So if anybody in the audience has further questions, again, use that box that you see on the screen and type in your questions, and I'll keep an eye open here for a question that might come in. One is talking about title. The title, you review the title, of course. We talked a little bit about that. But have you run into any certain circumstances that have created difficulties with the title? Any particular odd things that you've seen on titles?
Yeah, you certainly do see odd things on there. So there's obviously some major things, such as having the mortgage on there, making sure that the previous owner's mortgage is discharged. Also, you can see liens on there. So if someone's done work on the property and hasn't paid the contractor, there may be a lien on there. So you'll want to make sure that lien's there, because you certainly don't want to take over a property with such a charge. There's always an undertaking placed on the lawyer on the other side for the vendor to remove all of those charges, but you want to make sure that's reviewed. Also, charges, I have seen odd ones, such as one that I looked at was a property that was next to a farm, and there was a restriction on there, or an indication on there that the farm does make noise and does have fumes coming from it, and the people are aware that there is a farm next door, and that's just how it is. You're buying a property that has this farm next door, and it's not going to change. So that was something that was quite odd that I hadn't seen before, but you do certainly see things like that.
How did they word that on a title? How would they word that?
It talked about noise and air pollution.
Oh.
Yeah. So it was quite odd to see that. And of course, anybody that goes to that property will likely notice that, but it was just making that one further step that is there, and you are buying this property that does have that.
Yeah, buyer beware, that's what it comes back to. You know, if you're thinking of buying a property next to a pig farm, you check the title.
Yeah, and again, like I said, it's something that I hadn't seen before, but it did come up at this point. So.
Yeah. We've got another question, and this deals with depreciation reports. I think mostly strata we're talking about. People have heard about the requirement to do depreciation reports. Can you speak briefly about that?
Mm-hmm. Yeah, the Strata Act has been changed, and basically states that as of December 14 this year, all strata must have depreciation reports. Again, there's some exceptions, though. One exception is that if the strata, on a 3/4 vote at an annual or special meeting, votes not to have the depreciation report, the strata can avoid it. Similarly, if the strata is 4 units or less, it doesn't have to have one. Now, there are requirements with respect to the depreciation report. It has to be provided by a qualified person. This is a person who has knowledge to understand the scope and complexity of the common property. It doesn't go into much more detail than that, unfortunately, so I'm not really sure if they mean an engineer or if it's a contractor or if it's going to be a special new class of people that are going to be preparing it. I would presume for the most part it's going to be engineers. They're going to be looking at things like and whatnot.
But a lot of people are not quite sure what that is. What is a depreciation report? And maybe you can touch upon that a little bit.
Of course, yeah. So it's going to be a report explaining for the next 30 years what different issues may arise with respect to the common property. It's based on a site inspection of the property, and it'll look at what issues may arise with the elevator, with respect to the HVAC unit if there is one, things like that. So what are going to be the expenses over the next 30 years?
Mm-hmm.
I've had a number of clients have asked me, should I get one, shouldn't I get one, should we vote for it, should we vote against it? The one thing I have noticed is that on some requirements for financing, so when you get a mortgage, you purchase a property, there's the list of requirements with respect to that purchase and that financing. One of the requirements that I'm starting to see crop up is that we, the council, the lawyer, obtain a depreciation report. I'm not sure what the lenders are going to do if we advise them that this strata unit does not have one. I haven't run across that yet because depreciation reports aren't necessary as of yet. So that's still something that I'm looking forward to seeing what happens there. But as so far, they are requesting them, and there hasn't been a problem yet. I have talked to clients who have chosen to get them, and one client advised me that they have a 40-unit building, and they're told it's going to be about $8,000 to $10,000 to draft a depreciation report, and every 2 years you have to update it, and that's going to cost about $3,000 every 3 years. So that was one quote that was received. Another client told me they had a 6-unit building, and their advice is going to be about $4,000 to $5,000 to do the depreciation report. However, that report is going to be done by an engineer who is actually in the building, so that I'm not sure if that's going to be a special rate for that building.
Yeah, I've heard roughly the same figures myself. Now, this is my personal opinion. Everybody has their own. But I feel as a realtor that getting a depreciation can be a good thing. It can show that the strata shows responsibility for this. It outlines some of the future costs, and it's just it's kind of I shouldn't say seal of approval, but it gives that effect of confidence in the building and what to expect, and therefore that strata might stand out better than others in the marketplace. Now, whether it's going to give more value to the property, time will tell. But for many instances, I'm in favor of it, even though it's going to cost the council and the members of the strata a little bit more in the beginning.
I tend to agree. I know if I was looking to purchase a strata unit and I had 2 strata units that I couldn't decide between, I had one that had a depreciation report and it looked pretty good, I would definitely lean towards that property. Everybody's unique, of course, but that would be my personal view as well.
Yeah, I think so too. Well, listen, we're running long, but I think we've gone over some really great stuff, and I really appreciate your time, Christian. And hopefully we'll get you back on a program, and we'll think of some other neat topics for home buyers and sellers. So thank you again.
Thank you very much, and thank you everybody for paying attention and listening tonight.
Okay, great. And like I said, we'll put this in the archives, and if anybody wants a copy of this, We'll have it available, and of course you see Christian's information right there. You can give him a call or shoot him an email, okay? Okay, thanks again, Christian.
Thank you, Bruce.
Okay, bye-bye. So that wraps up our webinar for tonight, and I just want to thank everybody for coming. The next webinar is May 2nd, 8 p.m., Protecting Homes Against Earthquakes. Living in Victoria, everybody's aware that we're in an earthquake zone, and I thought that we'd share some information about what home buyers and home sellers, homeowners, can do or that should be aware of when it comes to protecting homes against earthquakes. And we'll have a guest in to talk about that issue. You can register for that program at victoriahomechat.com. Again, 8 o'clock, May 2nd. And so I just want to thank you for your participation. And if there's any questions, you can always go to victoriahomechat.com. Thanks very much, and good night.